Shirgawi Ali al-Hajj is a man who was born in Yemen. Today he's about 35 years old. He's a very slight man, probably 5'3", 5'4", 110 pounds. He's a client of ours from Yemen. Shirgawi, as we call him, was kidnapped by a Pakistani and intelligence service and the CIA. He was kidnapped from a house in Karachi, Pakistan in February of 2002. Shirgawi was imprisoned in Karachi for a period of time. He asked when he was picked up to speak to his embassy, and the folks in Pakistan told him that he had no right to speak to the folks from the Yemeni embassy. Shirgawi was shackled. They put a diaper on him. They blindfolded him, and they covered his head. They covered him from head to his knees in a sack type thing. The escorts took him out of the prison in Karachi and told him, "God save you from the Americans," and said to him a very common Arabic wail, "Your mother's praying for you." Shirgawi was put on a plane in Karachi, and he was flown to Amman, Jordan. Shirgawi was imprisoned in Amman for 2 years. For the first 9 months that he was there, Shirgawi was questioned by Jordanian intelligence. He was told by the Jordanians that he was being held at the behest of the United States of America. And it was clear to Shirgawi that the questions that were being asked to him, being asked by his Jordanian interrogators, were being read and clearly came from the United States. This was the awkward way you would read questions. And he'd be shown pictures and asked to identify people who were Al-Qaeda or related to terrorism in some way. Shirgawi didn't know the answers to the questions, and he couldn't identify the people in the pictures. So Shirgawi was subjected daily to falanga. Falanga is foot beating. It's foot whipping. It is a specialty of the Jordanian secret police. It is extremely painful. You're held down. The soles of your feet are beaten with a rod. It leaves few marks. You can tell it if you give somebody a mark later, but it leaves no other marks. But it is painful beyond belief. It's an ancient form of torture. And you can't walk after your feet have been beaten. He held out as long as he could, and ultimately he started answering questions from the Jordanian secret police, and he started IDing the pictures. What he first did is they'd show him pictures and say, "Are these people Al-Qaeda?" And he said, "Yes, they all are." The Americans weren't happy with that, and he was beaten. So then he decided that he would pick every other picture. 1, 3, 5, 7, 9 as being Al-Qaeda. The Americans were not happy with those answers, so Shirgawi was beaten. Finally, he started identifying random pictures as associated with Al-Qaeda, and that made everybody happy. After 9 months of the beatings and interrogations, Shirgawi was transferred to another Jordanian secret jail, and he stayed there for another 13 months. Shirgawi will tell you today that the 13 months in Jordan after they stopped beating him is superior to his current confinement in Guantanamo. He says that the guards there were kind to him. He said that some of the guards, who he got to know very well, gave him their cell phone and let him call his family in Yemen to say that he was alive and okay. After 2 years in Jordan, on January 4th, 2004, a CIA Gulfstream jet left Frankfurt, Germany, flew to Jordan, tail number N313P. We know it's a CIA jet. We know that it was chartered by the CIA. And it picked Shergawi up and took him to Afghanistan. In Afghanistan, he was taken to Kabul. Before I go on, given this crowd, it suggests to me some questions that we ought to think about. Kidnapping this man in Karachi, taking him to Jordan, and having him beaten at our behest. Did the United States violate the Convention Against Torture, the International Covenant on Civil and Political Rights, and the Geneva Conventions? I'm convinced that the answer to all those questions is yes, but I'd be happy to discuss it with you as we move along. Shergawi was held in Kabul in what the men in Guantanamo call the dark prison. It's an old prison in Kabul that the Soviets used when they were in Afghanistan. It's virtually no light and no hope in Kabul. September 20th, 2004, Shergawi was taken to Guantanamo, and he remains in Guantanamo today. I found this on the internet a couple of weeks ago. It is a public site. I will tell you that I had to have a secret clearance to go to Guantanamo, and everything in Guantanamo is super secret. But this is actually a picture of Guantanamo, this public, that's on the internet, that some organization has gotten from obviously from the aerial camera. That's Guantanamo. The red lines are the edges of Guantanamo and Cuba. Over on the left side is the airfield. That's where we go into. That's where we stay in the Guantanamo version of the Bait Motel. Over on the right side are the prisons, and that's actually a picture of prison camps. The prison camps are surrounded with, of course, barbed wire, concertina wire, all that, and then ultimately surrounded with 2 layers of the green mesh that you put on tennis courts so that the men can't see outside and can't see that ocean that's right outside their door. Shergawi's been held in Guantanamo since September the 4th. We represent 6 men from Yemen, and the other 5 are starting their 7th year in Guantanamo. These men have never been charged with a crime, have never been subjected to any military commission and will not be, have never been before any fair judge to determine whether they should be held or not. I'm going to drop back now and give you a little context for it. In January of 2002, the Rasul lawsuit was filed in Washington, D.C. Think back in your own mind to December 2002. This was a few months after September 11. And as a country, we were upset, terrified, and angry. 2 lawyers, Joe Margulis, who's now at Northwestern Law School, and Clive Stafford Smith, who used to do death penalty work in the South, is a Brit, he's back there now, filed a Rasul suit in Washington, D.C. They received death threats for filing that suit. They said that it was their belief that these men were entitled to petition for habeas corpus, were entitled to have somebody to decide whether they should be properly held or not. During this period, the United States had opened Guantanamo and even refused to say who they were holding. They were not held as prisoners of war. They were held under circumstances. They wouldn't tell family, they wouldn't tell the Red Cross, they wouldn't tell anybody who was there. The U.S. District Court in the D.C. Circuit quickly dismissed and affirmed, saying these men had no right to be heard. In June of 2004, the Supreme Court decided the Rasul case. 6 justices held that the application of the writ of habeas corpus to these men in Guantanamo in a piece of Cuba that was completely under the control of the United States was consistent with the historical reach of habeas corpus. The Department of Defense had a very quick response. They created combatant status review tribunals. They were created 1 month after Rasul. Let me ask you to focus on one thing for a minute. I'm getting ready to talk about these CSRT proceedings, the Combatant Status Review Tribunals. They're not military commissions. When you look at the paper, you'll read about military commissions. Khalid Sheikh Mohammed is supposed to go before a military commission down there. There are lots of problems with the military commissions, but that's not what I'm talking about. Of the men down there, there are approximately 10 who've been charged with military commissions. They say maybe another 12 will be. Sometimes the government says 80 will be. My men never have been and never will be. They're being held, and they're being held pursuant to the decisions made by these CSRT boards. I want to tell you about it because the Supreme Court decision that's going to come down in June is related, is really premised on these CSRT proceedings. So what is a CSRT proceeding? A man is brought before the CSRT. I've already told you the Supreme Court says is going to decide whether it's a substitute for habeas. There's 3 anonymous military officers who make up the CSRT board. There are no rules of evidence. The men are not entitled to have lawyers to represent them. There is a presumption in favor of the government's charges. Let me pause on that for a minute. These men are taken before the CSRT board for the CSRT board to decide whether they are unlawful enemy combatants or not. The government has charges against them. He went to Afghanistan in 2001 and was associated with the Taliban. He trained at Al Farouk training camp in Afghanistan. The charges are presumed to be true. Not the evidence, the charges. But the men do have the right, these Arabic men, by and large, although there are many people, other Arabs there, to try to rebut the written presumption. But they are presumed true. And as I indicated earlier, these are not military commissions. The CSRTs provide them with the right, the men the right to call witnesses reasonably available. They have the right to present evidence if available. Think about it. You're picked up in the middle of the night and taken to Guantanamo, and you have no contact with your family or anybody else, but you have the right to present evidence. They have no right to see the classified evidence against them. A Georgian named Michael Wiggins, testifying on behalf of the Department of Justice, testified in June that it is his belief that the men, as their administration's belief, that the men who've gone through CSRT proceedings can be held in perpetuity. In perpetuity. The Department of Defense position is that these CSRT proceedings satisfy our most basic views of due process. They say there's no need for habeas, there's no need for a judge, there's no need for a lawyer, that these proceedings are proper under our law and under our Constitution. Well, the truth is that the CSRTs in practice are anything but. One of our agencies, and I've forgotten which one, I think it was Associated Press, filed a FOIA request with the government, and after a great deal of fighting, got transcripts of 100 of the CSRT proceedings. And in fact, when you look at those transcripts, in those 100, the United States produced no witnesses because their charges were presumed true. Why would you mess it up with a witness? They gave the detainees no documentary evidence prior to the hearing in 96% of the cases. The requests by the detainees for other detainees as witnesses were denied in 76%, 74% of the cases. And the only documentary evidence that the men were allowed to bring were letters from family and friends. The CSRTs are repeated every year to see if the men have continued to be unlawful enemy combatants. I was down there in Guantanamo when one of my men, Mohammed al-Adahi, was called before his ARB. I said, let me go with you. And they said, no, you don't understand. These proceedings are not for lawyers. These proceedings are administrative and military. They refused to let me go with him. But the truth is that the proof is in the pudding on these CSRT proceedings. There were actually 103 transcripts produced. I'm going to call it 100 just to make it easier. In 97 of them, in the transcripts that were produced, 97 of them, the men were found to be unlawful enemy combatants. But guess what? In 3 cases out of 100, the CSRT panel found that the men were not enemy combatants. The men were not told. The Department of Defense convened a new CSRT proceeding. They excluded the detainee from it. The new panel looked at the evidence, and in 2 of those 3 cases, the CSRT panel found that sure enough the guy was an enemy combatant, and therefore you got 99 out of 100. But in 1 case, a second panel found that the man was not an enemy combatant. Well, you know what the Department of Defense did? They convened a 3rd CSRT proceeding, excluded the detainee, and lo and behold, the 3rd panel got it right and found that the man was an unlawful enemy combatant. In the 103 transcripts produced by the Department of Defense in response to the FOIA request, 100% of them were found to be unlawful enemy combatants. In October of 2006, just before the last election, the Military Commissions Act was passed. Part of the Military Commissions Act stripped, or purported to strip, the federal courts of any jurisdiction to hear habeas petitions. You remember Rasul had held that the men were entitled to habeas. Just before the last election, and none of our senators or congressmen showed much guts in connection with this. This law was rushed through, and the law was passed stripping the federal courts of the right to habeas for these men. The right to habeas corpus is the fundamental part of the rule of law in our Western tradition. It goes back to King John and Runnymede. It is so important that it is the only individual right that was in our original Constitution. Now, if you think about rights, you think about the Bill of Rights, the amendments, right? The things that were added. In the original Constitution, the only individual right included, presuming that there's not a right to own a gun, the only individual right included that has traditionally been found to be there was was the right to the privilege of habeas corpus. The government has the right to pick any of us up today and put us in jail. Absolutely no question about that. They could come in here today and arrest any one of us. The state has that power. The question is, what happens next? Is there a right for you to be taken before an independent judge and have that independent judge say whether you are properly held or not? The question before the Supreme Court now is whether the Military Commissions Act improperly suspended these men's right to habeas corpus. As I said in Rasul, the court said they had the right. The Military Commissions Act took it away. The administration says that these CSRT proceedings, the thing I've talked about at such length, are adequate substitutes for due process. The Boumediene al-Oda cases, Supreme Court this summer, the United States Supreme Court will decide perhaps one of the most important civil liberties issue in our country's history, having held that these men were entitled to habeas corpus. It will decide whether it can be taken away by Congress. It turns on a very abstruse legal issue, which I won't spend much time on, but it turns on the issue of whether, when our country was founded, the right to habeas would have been extended to men who were not in the United States of America, who were not citizens. In the original 13 states, would these men have had the right to habeas? This is something I just show people for fun. When we were in the process of doing the briefs, and it's not my cases in the Supreme Court, but we were all helping, the lawyers, Seth Waxman, for our side, asked us to look at the original 13 colonies to see if there are any indications that men, before our Constitution was adopted, had the right to habeas if they weren't held inside the country. And we went down to the archives, and in the revolutionary records of the state of Georgia, there were a couple of petitions for habeas corpus heard for men who were outside, who were not citizens and outside the state of Georgia. Of course, it was found that they were entitled to habeas, but the question is, could it be heard? And the answer is clearly yes. This is one of my favorite quotes. The great privilege of habeas corpus and trial by jury are the supreme protection invented by the English people for ordinary individuals against the state. The power of the executive to cast a man in prison, they can pick any of us up anytime, without formulating any charge known to the law, and particularly to deny him the judgment of his peers is in the highest degree odious, and is the foundation of all totalitarian government, whether Nazi or communist. And I bet you know who said it. Winston Churchill said it in 1943. There are 280 men still in Guantanamo. There are almost 100 men from Yemen. All 6 of my clients are from Yemen. There have been 10 men charged before military commissions. Maybe the 12 who were brought in from secret sites will be charged. 2 or 3 of them have now been charged. But for the remaining 258 men, they're in Guantanamo today. Our clients, except for Shagawi, have been there more than 6 years. They've been there longer than Senator John McCain was held in North Vietnam. They've had no hearing before a judge. They've had no trial. They've had no charges brought against them other than in the CSRT proceedings. And they are not treated as prisoners of war. They are held in what is essentially a maximum security prison. In Nuremberg, We could have shot the losers. We could have made the decision that the men who were responsible for the atrocities in Germany should be lined up and shot. And there were a lot of people who supported that view. Instead, we tried them. We tried them in an open trial. We took the moral high ground in connection with Nuremberg. We said that the rule of law was too important to ignore. Today, Guantanamo is a word that has a meaning, and I don't know the exact number, so I always say in more than 100 countries around the world. It may be a word that has a meaning in 200 countries around the world. At this point, it doesn't much matter what happens in Guantanamo in terms of our image in the world. The word Guantanamo is set in people's minds. It means anti-Nuremberg. And you can say many things worse than that. I believe that Guantanamo and the way we've done it is our great national shame, and I believe it is about us and who we are and what we believe. And thank you very much. I am happy to answer questions.
Thank you, John. As usual here in our Q&A, we ask you to ask questions rather than make presentations. And the more brief, concise questions are asked, the more people have an opportunity for such. The floor is open.
Jim?
Jim Sutherland, no relation. But all the presidential candidates, all 5 secretaries of state, as a preview of Peter White's speech, want Guantanamo closed. What does that mean to your case if in January, February next year it's announced that they're going to start closing it? What does it mean to your case if your people, where will it go? Do you know what's going to happen?
The question is, with all the presidential candidates saying Guantanamo should be closed, the 5 secretaries of state who met here, 3 Republicans, 2 Democrats, all saying it should be closed. What happens if Guantanamo actually is closed shortly after the administration changes? I have very little faith in the political process there. The Secretary of Defense, Acting Rumsfeld, has said that Guantanamo should be closed. The Secretary of State, Condoleezza Rice, has said that Guantanamo should be closed. The President of the United States has said, I would like to close Guantanamo. The only person we haven't heard from on that subject is the Vice President. But the fact is that nothing has been done to close Guantanamo. There's construction going on down there right now. They've set up a great tent city for trials. There are new buildings going up. I see no suggestion that Guantanamo is going to be closed. What would happen if they closed Guantanamo is, of course, part of the problem. There are 100 men from Yemen. There may be 3 or 4 or 5 of those who will actually be charged. If they're going to be charged, there's absolutely no reason why they can't be brought back to the United States of America. If they say 80, which is what they say sometimes, out of the 280 are going to be charged, bring them back, put them in jail, and let's try them. Let's put them on trial. If these are criminals who had something to do with 9/11, let's try them. Well, what about the rest of the men? Well, our country's political relations are so lousy with some governments that we can't send them home. All of our men are ready to go home to Yemen tomorrow. Our government does not have good relations with the government of Yemen. If you know your international history, which I bet you do, Yemen was not a country until 1996. Southern Yemen was communist, a communist puppet government. Northern Yemen was the opposite. It was unified. Our government doesn't like the government of Yemen. Our government says that they can't send the men home to Yemen because the government of Yemen will not sign a piece of paper saying that we promise not to torture them if they come home. The government of Yemen says our Constitution prohibits torture. We're not going to sign any such piece of paper. Let the men come home. But the government of Yemen has no power to put pressure on us. I don't have a clue, Jim, what will happen with the men if somebody actually decides to close Guantanamo. It will never happen. Leave aside the 80 men who they say they might try, who I see absolutely no reason not to bring here and try. The rest of them, the men who will not be tried, the one thing that will never happen is that they will never be brought to the United States of America because we don't have the nerve to bring those men here. They've got to be sent home, and we've got to do it as quickly as we can. Yes, sir.
What is your prediction about the June Supreme Court Guantanamo?
Question is, what's my thought about the Supreme Court decision, Guantanamo that will be made this term in June? It's going to be a 5-4 decision. It depends on Justice Kennedy, as everything seems to these days. The government came very close to conceding that the constitutional right to habeas attaches. And I believe that the court will so hold. Our great fear is that the court is going to say, yes, they have the right to habeas, but there's no question that you can have a substitute for habeas. And that they will say, well, let's see how these CSRT proceedings work out. Let's get some records on that. We'll look at that when it comes back up. In which case, the government will have won a great victory because they have stalled now for 7 years successfully.
John, will you comment on two people, Colonel Morris Davis and Susan Crawford?
Question is, will I comment on two people, Colonel Morris Davis and General Susan Crawford? Yes, I will. Mo Davis is the defense lawyer, right?
Well, the nation describes him as having undergone a conversion from
yes. Okay.
chief prosecutor to chief whistleblower.
Right. Let me start with General Susan Crawford. She is what's called the convening authority for the military commissions. We have a terrific military justice system. Has nothing to do with the military commissions, but a terrific military justice system. And I told people all along, I'll take my men before a courts-martial any day. She is the convening authority, and the convening authority is supposed to be like a grand jury. She is supposed to decide whether these charges should be brought or not, whether it makes sense to bring the charges. She is clearly under the influence of the administration. She is not being objective. She is putting her thumb on the scale. Colonel Davis has said that she is rigging the system so that there will only be convictions in the military commissions. And I think it is a disgrace, and I believe it is something that will haunt our military for many years to come. Most JAG officers I talk to have very little sympathy for what's going on in Guantanamo. Colonel Mo Davis is the one who was a prosecutor who was going to do the military commissions, or a couple of them. He was head prosecutor. And he determined, he's career military, he determined last fall that the military commissions are being set up in a way that's rigged. He had told his team that they were not going to use any information that was gained through torture. One of the things I left out on Shirgawi is Shirgawi signed an 80-page confession that he's never read and still hasn't read, but it caused the beatings to stop. Colonel Davis said, if we're going to prosecute these people, we're going to do it fairly. And he said, there's no way to do it fairly. I resigned my commission. And he's getting out in June, and I think he's a great hero. Yes, ma'am.
Chicago, do you have any understanding of why he was kidnapped? Was it guilt by association, guilt by because somebody said he was doing something? Or what was the beginning point in his life for being kidnapped?
Shagawi had been in Afghanistan. There were, for all of the 1980s, the United States government and Arab governments encouraged men from poor places in Yemen to go to Afghanistan and fight the communists who were running Afghanistan. The question, which I forgot, was forgot to say, was what were Shagawi's beginnings? How did he get kidnapped? Shagawi, along with 16 other men who were picked up at the same time, had been in Afghanistan, had left Afghanistan, were back in Pakistan, and he has been accused of being involved in Al-Qaeda in some fashion, and that's why he got sent to torture.
So he was encouraged to come to Afghanistan to fight the communists.
He was encouraged.
As a hired gun. Okay. And then the people who were fighting the communists, how many of them were now considered Al-Qaeda? I mean, one and one?
Complicated question about fighting, going there to fight the communists, and how many of them were associated with Al-Qaeda. And I say it's complicated for this. Of course, the Russians left Afghanistan having failed to conquer the country, just as our country and others are going to find it impossible to conquer Afghanistan. And the Taliban was involved in a civil war with other tribal pieces in Afghanistan thereafter. Men from Yemen went to Afghanistan still, many to fight for the Taliban. The Taliban was the government of Afghanistan. We didn't recognize it as such, but it was. If there was a government there, the Taliban were it. The Taliban clearly sheltered Al-Qaeda, although I would suggest to you that most foot soldiers don't know a whole lot about what a government is doing in that regard. But they were with most of these guys, or some of these guys, were fighting for the Taliban against the Northern Alliance, which was not illegal or improper or anything else. It was a guy named Rashid Dostum, who was one of our allies by the time we invaded, who was a fellow from the Soviet Union, was against the Taliban because he really liked women and whiskey. He didn't fight in the uniform, would have been an illegal enemy combatant under our definition, except he was our ally. And he was fighting the Taliban. These men were going there. We reached the time that normally you stop questions. But Bill, one last.
I wondered if you could return to the Supreme Court case that's come up this summer. You indicated that you fear that they'll say the right of habeas corpus is available to your client, but you indicate that it's a possibility, as in other instances, they will come up with, or at least leave open the possibility that some variation of some sort of hearing procedure will allow something to happen that will not give your clients the rights you need under a true habeas corpus situation. Are we, under the Military Commissions Act, I believe you outlined there, they had no right to tick off a bunch of things which under habeas corpus we're supposed to have. Are you perhaps suggesting that these procedures will be some variation of what we've already seen before, and therefore we really won't have habeas corpus even if they rule, quote, it's available?
The question is, if the Supreme Court rules that the men have the right to habeas but say we need to wait and see whether the system currently set up is working, what will happen. I'm not worried about that. Yeah, I'm very worried about that. The Military Commissions Act, I didn't go into it, also set up a right to appeal the decision of the CSRT to the D.C. Circuit, not the District Court, but to the Court of Appeals. The only right to appeal is the right to appeal to determine whether the government's procedures were properly followed or not. And by the way, we're in that process now, and they weren't. They can't even give us a record in most of them. But I worry that a political compromise will result in the Supreme Court saying, no question, these guys got the right, constitutional right to habeas. But are the CSRT proceedings, which I showed you the infirmities of, are they an adequate substitute for habeas? And the court could say, well, you know, we decide these questions when we get a fuller record. We have no appeal before us that has all of the CSRT proceeding, the decision by the D.C. Circuit. Let's get a full record and then decide whether they're an adequate substitute, which means the government has 2 more years before it gets back to the Supreme Court. And that's our worry. It would be, there's enough information, including that I just gave you, before the Supreme Court, for the Supreme Court to say, this is not an adequate substitute for habeas. It simply is not. If you don't have a lawyer and government's evidence is presumed true, and you can't see the evidence against you, then it's not an adequate substitute. And I believe that would be the principled decision that's made, and it's one that I very much hope the Supreme Court will make. We're keeping our fingers crossed.
John,